That was a new little thing.
All right. 55th Circuit Court is now. Roy G. Meek presiding.
May be seated. I am the case of People versus Crystal Lee Hovina.
John Presidis appearing on behalf of people.
Got more for the defense.
Do we have Crystal Lee Hovina?
Yes, sir.
All right. This was set as a status conference and a motion to revoke bond. How are we going to proceed today?
It's the prosecutor's motion, Your Honor. As far as the status conference goes, I think one will control you.
All right. You may proceed with your motion, Ms. Ambrositis.
Thank you, Your Honor. We filed with the court notice or a motion to revoke the defendant's bond. There's a pretrial release order that's not only in the court file, but is attached as an exhibit to our motion that the defendant acknowledged. Part of that pretrial release order was she's not to commit any crime while released, is not to use alcohol, marijuana, or illegal controlled substances, to participate in a substance abuse testing or monitoring program. About on 5/13/2021, she was arrested for operating with a high BAC. Blood alcohol was over 0.2. That is also attached. And again, court record would show in the 80th District Court that she has been charged with that crime. So based on those, we would ask the court to revoke her bond and establish a new bond sufficient enough to ensure, with conditions applied, sufficient enough to ensure that she's complying with those bond conditions. Thank you.
Response?
Your Honor, it is a fact that my client has been charged with crime. No finding of guilty on a reasonable doubt has been established. However, after discussing this with my client, it seems that it would be in her interest to, at a minimum, plead no contest to the establishment of probable cause that the crime was committed, which would be a violation in itself. And then schedule sentencing on the contempt portion for a later date. I'm not certain that we're prepared to go forward with the plea because the last plea offer that I see is plea as charged with no agreement as to sentencing. So that's where we're at. As I've advised Ms. Ovinga, I think if you stand mute or plead no contest to the bond violation, then the court would take the appropriate action as discussed.
Just as a point of discussion, Mr. Moore, her guidelines are 0 to 34 months, which means that under the new statutes that were passed, she is capped at 12 months.
Your Honor, I recognize the prosecutor's position on this, and she's made it clear in a number of other cases. My concern with this is that that's a rebuttable presumption, which can be overcome either by argument from the prosecutor or by the court sua sponte. And so what I would be doing would be pleading my client as charged with a guideline being 34 months. It is not outside the realm of possibility that the prosecutor may, through her elocution, convince the court to go above that rebuttable presumption. Further, we would have no control over the court. So I think that Briggs Killebrew still has effect and efficacy for protecting my client's interest. I'm not here to argue this point. I'm simply stating this to advise the court and counsel why I am reluctant to enter a plea under these circumstances, or at least advise my client to do so.
Court's going to enter not guilty pleas to the contempt of court charge for violating bond condition. The court is going to revoke the bond and forfeit it. The defendant is to report to the Clare County Jail today by 5 o'clock. The new bond will be set. Bond on the new bond would be $50,000 cash surety, 10%. One of the
I'm
conditions
sorry, I
would
didn't hear
be
that.
$50,000 cash surety, 10%, and one of the conditions would be is that she be put on alcohol tether. Also,
I am, sir.
you're already on alcohol tether?
I believe it's
Yes,
a
sir,
condition
and
of the bond.
I call Compass every day.
Okay, all right. Basically, all you have to do is post the new bond, then, but you do have to report to the jail.
So turn myself in at 5 o'clock today and bond right back out.
Yep, you can do it anytime today. You don't, but if you don't do it by 5 o'clock, a bench warrant for your arrest is going to issue and bond's going to be doubled.
I have a question. Does any of this money that I keep paying to bond out go towards my fines and costs?
Nope, not when you give it to a bondsman. If you post it yourself, it does.
Okay.
All right, anything further with this case? All right, see you off.
Crooked. Fuck.
On the case of Vic versus Jonathan James Fuller.
Morning, Your Honor. Mark Webb on behalf of the people.
Please, the court's got more defense.
You are Jonathan James Fuller?
Mr. Fuller, you need to unmute your microphone, please.
Can you hear us, Mr. Fuller?
Yes, sir.
All right. This was set as an arraignment. How do you wish to proceed, Mr. Moore?
Your Honor, I advise my client of his rights. We waive reading of the information, received a copy of that, already waived preliminary examination. I offered my client the opportunity to waive today's hearing in writing. He asked that to be brought in. Nevertheless, my client will stand guilty to the charge and ask for this matter to be scheduled for pre-trial conference.
All right, not guilty pleas will be entered on behalf of the defendant. This will be set on the trial docket with a pre-trial being scheduled next. Anything else?
Your Honor, just briefly as to bond, my client is on parole right now. He has requested that the court reduce the monetary amount. Does recognize that there will still be a cash value to this. He has proceedings pending in Ogama County that are set for conference in August and a trial in October. Further, he has a matter in Muskegon County that needs to be attended to. And he wants to get himself arraigned on that. So for those reasons, he's asking the court to reduce the monetary amount.
Mr. Webb, on behalf of the people?
Thank you, Your Honor. I think those are reasons that the court should maintain its current bond.
There's the bond was reduced at the last court hearing in district court, so the court's going to leave the bond as is.
Very good, Your Honor. Thank you.
On the case of Dick versus Mary Jo Miller.
Good morning, Your Honor. Mark Webb on behalf of the people.
Please, the court, Scott Moore for the defense.
You are Mary Jo Miller?
This is. Can you hear me, sir? Can you hear me, sir?
It looks like the court is on mute.
Do this.
Can you hear us now, Ms. Miller?
No, we can't hear her.
No, we can't hear her.
Can you hear me now?
Yes, yes. Can you
Okay,
hear
yes,
us?
I can hear you.
All right. You may proceed, Mr. Moore.
Thank you, Your Honor. Today is the arraignment on the information. We received a copy of the information by reading of that document. The client stands mute. We ask this matter be set on the trial docket and scheduled for pretrial conference.
Not guilty pleas will be entered on behalf of Ms. Miller, and this will be set on the trial docket with the pretrial being scheduled next.
We can call that now if you want. I don't think you'll.
Calling the case of people versus Vincent Edward Mumford.
Morning,
All
Your Honor.
identified?
Good morning, Your Honor. Mark, on behalf of the people.
All right,
Please, the court, Scott Moore for the defense.
and Mr. Mumford on bond, or?
Yes, Your Honor. We're here on motion for show cause for failure to appear at the last hearing. I have no new information to report to the court except that we have continued our efforts to contact Mr. Mumford, but without avail. Further, I've been advised by his attorney in Isabella County that he has had similar results trying to reach Mr. Mumford.
Mumford's bonds will be canceled and forfeited. New bonds of $100,000 cash in each case set.
$100,000
Each
cash surety, 10%.
cash.
Cash on. Thank you, Your Honor.
Address that later on when he comes in.
Yes, sir. Defendant's own name.
No, just cash.
Just cash. I wasn't told abject failure. No, thank you.
Are we issuing a benchmark judge or no?
Yes,
Oh, yes.
100,000 cash,
Okay.
both five.
Okay. Didn't hear that.
On the case versus William Rydell Yates.
Is Mr. Yates lodged?
Wendy Cosgrove is the phone that you can call.
Thank you. It's driving great.
Michelle and Besides, appearing on behalf of the people.
Please, the court, Scott Moore for the defense.
Mr. Yates, can you hear us?
I think it's still connecting.
Still connecting. Okay. Still connecting, or?
It is, it's still showing that they might have,
You might not want to.
they might have low service.
This is a pretrial. Has a pretrial summary been filed? In the court file at this point. Did you receive one, Mr. Moore?
I don't see that I did one. I see that there was a PCC form.
That's what I had. Fred.
Okay.
If it's all the same with prosecution in the court, I'd like to schedule this for a police status conference in 2 weeks. Further, Big access here, but we can't hear.
It's still showing connecting, so I'm guessing.
Can you hear us, Mr. Yax? We're having trouble getting Mr. Yax in, and you just want a new status conference set in 2 weeks. Can we just adjourn this for 2 weeks?
I have no objection.
Any objection, Ms. Ambrositis?
No.
And then you can contact your client and either he can appear in person or make other arrangements for connection.
Your Honor, that's what I was going to ask the court. I wanted to specifically have the client come in, and that's been true for a couple of people this morning where we thought we had.
Yeah.
So I knew that if I could,
Fine, you can.
if the court says that he must be here, can be here, I suppose. It's just folks are taking advantage of
But
So-
if we're not having good connections and they're not coming in.
Oh,
then they should come
Mr.
in.
Yax is now connected. Enough for them.
Mr. Yax, can you hear us?
Yes, sir. we're good.
Hello? Yes, sir, I can hear you.
All right. We're going to adjourn your case till June 14th at 8:45 a.m. The court's going to request that you come in court to court in person. All right?
Time and date.
You're all set, Mr. Yax. You can sign off.
What time and date, sir?
8:45 a.m. Be here by at least by 9. You need to be here by at least 9 o'clock. All right?
All right.
Tomorrow?
What day again?
June 14th.
June 14th. All right, thank you, sir.
Calling the matters of People versus Scott Elwood Sizemore.
Schumer says, ping a bit, people.
Got more for the defense.
Court set this as a status conference. You are Scott Elwood Sizemore?
Yes, sir. Your Honor.
This is currently set for a jury trial in July.
Yes, sir.
Anything? And you're still requesting the trial, is that correct?
Yes, sir.
All right. Anything need to be discussed at this point?
As I said earlier in another case, I think if Mr. Sizemore were here, and I know that he wouldn't have been able to be here because of the recent contact. So, but I think if we could schedule at least one more status conference, maybe after the 14th, because that day's getting pretty logjam, where Mr. Sizemore would be invited to come in, then we can sit down with the prosecutor and some meaningful negotiation.
Absolutely.
Okay, we'll set a new date, send it out for status conference, probably closer to 2 to 3 weeks before the trial date.
Great.
And be prepared to discuss jury instructions if it's not going, nothing further has happened. And Mr. Sizemore, you're going to be present in the courtroom, okay?
Yes, Your Honor.
All right. All set.
All right, Mr. Sizemore, we'll talk. Thank you.
Thank you, Mr. Moore.
Brings us to the People versus Jonathan William Mackey.
John Bezaz, appearing on behalf of the people.
And do we have Jonathan William Mackey?
He needs to just unmute the mic.
Can you hear us, Mr. Mackey? You need to unmute.
Yes, I can hear you.
All right. Again, this was just a status conference. We have a trial date set for August. Anything new happening, anything that we should be discussing at this point?
No, Your Honor.
All right. Again, we'll set a final pretrial. Well, we have one final set for July 27th, so hopefully at that point, if nothing's resolved, then we can go over preliminary jury instructions. All right.
Very good, Your Honor. Thank you.
You're all set, Mr. Mackey.
All right.
Is that takes care of all your cases
Yes, Your Honor.
for this morning?
Hey, I feel like my pen's burning over here.
In the cases, the People versus Stephen Anthony Mexner. Join. Can you hear us, Mr. White?
I can, Your Honor. Can you hear me?
Yes. Can you hear us, Mr. Mexner?
Second.
Calling the cases of the People versus Stephen Anthony Mexner, counsel identify for the record, please.
Sean Bezaz, appearing on behalf of the people.
Gerald White representing Mr. Meichner.
You are Stephen Anthony Meixner? You are Stephen Anthony Meixner?
Yes, I am.
All right. Today was set for as a pretrial. A couple of pretrial summaries have been submitted to the court. Have you received those, Mr. White?
I have, Your Honor.
Court is signing those. Anything else you wish to do today, Mr. White?
Not really, Your Honor. We're not willing to accept the offers at this time.
Anything else from anybody?
Nothing from the people.
All right. We're all set. Mr. Mexner, you can sign off.
All right, thank you.
What? We're done with Mexner. In the case of the People versus Jeffrey Stephen Cicero Horton.
Sean Bezaz, appearing on behalf of the people.
Gerald White representing Mr. Horton, Your Honor.
And you are Jeffrey Stephen Cicero Harton?
He's on mute, Your Honor.
He has to unmute himself.
All right, Mr. Harton, you need to unmute.
There you go.
I'm unmuted.
All right. And you are Mr. Harton?
Yes, sir.
All right. Today was set as a pretrial. Has there been a pretrial summary submitted?
There has, Your Honor. I am in possession of it, and I've gone over it with my client. And I believe it's my client's desire to take advantage of that offer and enter a plea.
All right. And how old are you, Mr. Horton?
What's that?
How old are you?
I'm 33.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
This one was yes. I don't believe that we have one for.
All right. And what is the offer in this matter?
Your Honor, it's for the defendant to plead guilty to counts 1 and 2. Count 3 will be dismissed. BK 6-month cap on initial incarceration.
Okay.
I'll print the pretrial summary to the law library here in a moment.
All right. And Mr. Horton, you've been able to go over the information with your attorney, Mr. White, is that correct?
What is that?
You've been able to go over the information and discuss it with your attorney, Mr. White, is that correct?
Yes, sir.
All right. And Mr. White, is he waiving reading of the information for today's purposes?
Your Honor, we've waived the reading of the information at this time. It's my understanding that there will be a plea according to the proposal that was put on the record by Ms. Ambrositis.
Okay, and you're continuing the waiver of preliminary examination, is that correct?
That's correct, Your Honor.
Mr. Horton, you're being charged with count 1, police officer fleeing in the 3rd degree. That's a felony that carries a maximum penalty of 5 years in prison and or a $5,000 fine. Secretary of State will suspend your driver's license. Count 2 is police officer assaulting, resisting, or obstructing, a felony that carries a maximum penalty of 2 years in prison and or a $2,000 fine. And consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under 750.81D6 for another violation arising from the same transaction. Otherwise, the minimums are discretionary with the court. Do you understand the charges and the possible penalties?
Yes, sir.
There's one of 3 possible pleas you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stay on mute, in which event the court will enter a plea of not guilty for you. Do you understand the one of 3 possible pleas you may make?
Yes, sir.
Answering the count 1, police officer fleeing in the 3rd degree, how do you plead?
Not guilty. Right. I mean, let's. I need to talk to my lawyer. Like, saying.
All right, not guilty pleas will be entered on behalf, and we'll set this for a status conference on June 14th, Mr. White, at 9:20 a.m. So you can talk with your client.
Very good, Your Honor.
All right?
Yes.
Okay.
Which one was the date, Judge?
June 14th, 9:28 a.m. We have Mr. St. James.
He's in jail.
Okay. You're all set, Mr. Horton, you can sign off.
Fuck you.
Going to the case of the people versus Franklin George St. James II.
Mr. Ambrositis, appearing on behalf of the people.
Gerald White representing Mr. St. James.
Then you are Franklin George St. James II.
Yes, sir, Your Honor.
Previously, you appeared in court and pled to the charge of police officer assaulting, resisting, or obstructing. That is a felony. It carries a maximum penalty of 2 years in prison. The minimum is discretionary with the court. You also pled to the charge of child abuse in the 4th degree, a misdemeanor, carries a maximum penalty of 1 year in the county jail. And he also pled to the charge of domestic violence aggravated second offense. That is a felony, carries a maximum penalty of 5 years in prison. The minimum is discretionary with the court. The pre-sentence investigation report has been prepared. Sentencing guidelines for the most serious charge have been determined to be 5 to 23 months. Mr. White, have you had an opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Anything of a factual nature that you wish to add to, explain, or controvert?
Not of a factual nature, not, Your Honor, no.
Any objection to the scoring of the guidelines?
No, they appear to be accurate, Your Honor.
Ms. Ambrositis, on behalf of the people?
Your Honor, I've had the opportunity to review the pre-sentence investigation report where you'd find it to be factually accurate. I've also reviewed the prior record variable scoring and the offense variable scoring and find that to be accurate as well.
Mr. St. James, is there anything you wish to say to the court before the court passes sentence?
Yes, sir, Your Honor, I do. Are you guys ready?
Yes.
First of all, I want to apologize to the courts and to the community and to Your Honor for my misbehavior because I see it affects everyone and not just myself. Second, I'd like to ask for my sentence to be delayed so I can complete my probation and move forward with my life. I have moved up here with my son to be with my future wife, Tammy Spanky. We come up here from Flint to get away from my past life, the drugs and the drinking. And I have a great job at Husky Roofing and don't want to lose it. Please, Your Honor, I'm asking for a second chance to be a better father to my 3 children and my girlfriend's family as well. And I am a better person and to be a better person to our community. I also just find out my mother is sick. She's in the hospital and the only person that does anything for her is me. I'm the only one that's really there for both my parents. The COVID is seriously really bad in here. I've stayed to myself as much as possible to stay away from it. And if I do get out, I am going to seek a Vivitrol shot that helps me to where I won't drink no more, Your Honor, because I know that's been a problem in my past and I don't want it no more in my life. So and I found out not too long ago, my ex-wife had moved to her mother's, and I found out just the other day that they had all left my children there that are 8 and 10 years old, all alone all night. So I'm just asking for a second chance so I can get out, get my life together and put things back in order, Your Honor. And I forgot, I was on tethered the whole time that I was on bond for 10, 11 months. I had to pay for that too. So I was going to see about having time credited for that also, Your Honor. And that's all I have to say. Thank you.
Mr. White, on behalf of your client?
Yes, Your Honor, I would indicate that I've gone over this matter with Mr. St. James, and he indicated to me the same, that he has indicated to the court those issues that he wanted to bring before the court. And my observation is that obviously Mr. St. James, looking at his past record, driving as well as all the involvement he has had with the courts, it all stems from the consumption of alcohol, Your Honor. He has to get that under control, and that is necessary, or he's going to be back before the court again and again and again.
And I don't plan on that. I've quit drinking, smoking, and everything, so.
Ms. Ambrositis, on behalf of the people?
We ask that you follow the recommendations in the plea agreement in this matter.
Are there any victims present that wish to speak to the issue of sentencing?
Your Honor, Honor, I note that there is a Tammy Spanky. She is the victim in this matter. She appears on the screen here, but she's not muted. She's muted right at the present time.
Ms. Spanky, can you hear us?
Yes.
All right. Is there anything you wish to say about the sentencing here?
I mean, I just wish he would be able to get out and get back to life and his kids and stuff. And, I mean, he's hopefully can do better for himself. Seek treatment and stuff like that. I mean, he's not a bad person. He just, the alcohol.
Okay, thank you. Court has reviewed through the pre-sentence investigation report, does provide for sentencing guidelines of 5 to 23 months. In order to punish you for what you've done to attempt to rehabilitate you, deter others from committing similar acts of protection of the community, be the sentence of this court that you be placed on probation for a period of 18 months. Along with the statutory terms of probation, that you be given the following specific terms of probation. You must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician, or be with anyone you know to possess these items. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must perform 100 hours of community service. If you successfully complete those 100 hours, the court will reduce your fines and costs by $600. You must complete mental health or domestic violence treatment. You do have to complete the domestic violence treatment. If there's any mental health problems, then you have to do that following assessment by a qualified community-based service provider. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not change your residence unless you first obtain written permission from the field agent. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your release from jail. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must notify the field agent of service of any personal protection order upon you within 24 hours of that service, weekends and holidays accepted. Ms. Spanky, are you still there?
Yes, I am.
And do you wish to have contact with Mr. St. James?
Yes, I do.
All right. The court's not going to put that condition in place. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours a week. You will serve 12 months in the county jail with credit for 67 days served. That's on all 3 charges. You're not going to be on probation for the misdemeanor charge, only for the 2 felony charges. You must pay a crime victim's assessment of $130, court costs of $500, a fine of $500, and attorney fees of $500. How much are you charging for attorney fees, Mr. White?
It would be $1,500, Your Honor.
$1,500 in court-appointed attorney fees. Probation officer of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, and confine a probationer who is in violation of a probation condition or who is conducting himself inconsistent with the public good. You must not use, purchase, or otherwise possess recreational marijuana or be in the home of any or company of anyone who uses or possesses recreational marijuana. Must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from your field agent. You must set up an installment payment agreement with the Clark County Clerk's Office within 30 days of your release from jail. You must pay a supervision fee to the state of Michigan in the amount of $30 a month. If probation department decides to put you on supervised electronic monitoring, then the fee would jump up to $60 a month. Court has no objection to you going into an inpatient rehab unit after you've complied with 6 months in the county jail. If you successfully complete that residential substance abuse treatment, the court would suspend the remaining time. You are entitled to appellate review of your convictions and sentences. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days, sent directly to the court. Please sign the notice of appellate's rights form. Bond is canceled. You're remanded to the custody of the Sheriff's Department for carrying out the sentence. The sentences all run concurrently. You're all set, Mr. St. James.
Okay,
Good luck
I
to
have
you.
to talk to my lawyer.
Sure. Do you want to go into a breakout room with them, Mr. White?
Yes, Your Honor, if it please.
Thank you.
All right, you may.
Just one moment. All right, I'll go ahead and place you in that breakout room now. Jerry, you can hang up when you're done.
Okay, thank you very much. I appreciate it. Thank you.
Just so that you know where Todd's first client is the Sheriff's Department, and he's tying up the Sheriff's Department.
Okay.
So, if I can have a couple minutes, there are a couple unidentified people on here.
All right, we're going to take a short recess.
All right. All right. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. In the case of People versus Dylan Edward Dean Andrus, counsel identify for the record.
Morning, Your Honor. Mark Webb on behalf of the people.
You're muted.
Sorry. Todd Diedrich on behalf of Mr. Andrus now.
And you are Dylan Edward Dean Andrus?
Yes, Your Honor.
Previously, you appeared in court and pled to the charge of controlled substance, possession of methamphetamine. A felony carries a maximum penalty of 10 years in prison. The minimum is discretionary with the court. Pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 0 to 17 months. Mr. Diedrich, have you had an opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Anything of a factual nature that you wish to add to explain or controvert?
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Webb, on behalf of the people?
Thank you, Your Honor. I've read the report. I have no additions or corrections to make to it. And I also believe the guidelines are correctly scored.
Mr. Andrus, is there anything you wish to say to the court before the court passes sentence?
No, Your Honor.
Mr. Diedrich, on behalf of the client?
Thank you, Your Honor. I guess, Your Honor, what I'd like to point out a little bit in the PSI is under the negative factors, you know, it states that Mr. Andrus indicates he has an admitted substance abuse issue. And, you know, I acknowledge that having a substance abuse issue is definitely a negative factor. However, I think it's a positive factor that he's admitting it. And I guess I find that when these individuals are admitting it, it's really a call for help. I think Mr. Andrus would like some help in addressing that issue in my discussions with him. I don't think he's able to do it on his own, quite honestly. I think he needs some guidance to get pushed in that direction. And I was having a discussion with Mr. Webb about the new law and the presumption and what effect it might have on some of our prearranged agreements. This was a 12-month cap. I am asking the court to only sentence him to probation at this point in time, but I think that Mr. Andrus would agree with me that he would probably benefit the community and society in general if the focus was on some rehabilitation in terms of some drug counseling or rehab or something of that nature. And so with that, I asked that the court not impose any incarceration, but would focus on the rehabilitation of Mr. Andrus. He appears to be a very cordial person. He appears to have a lot of untapped potential, let's say. And I think if you had the right guidance, you could probably do some very positive things. And but I think also that having a substance addiction can really inhibit that from ever coming to fruition. And so I'd like to see Mr. Andrus, you know, get more of the potential that he appears to have than what he's been putting forth. So that's what I would ask for the court. Thank you.
Mr. Webb?
Thank you, Your Honor. After trying to do a little research and with the help of my boss, I agree. I think the new laws indicate there's now presumption for probation. However, the probation department recommended 18 months. I would ask that at least be 2 years.
You're talking about probation, sir?
Yes.
Yes, about the term. All right. Court has reviewed through the pre-sentence investigation report. Does provide for sentencing guidelines of 0 to 17 months. In order to punish you for what you have done, to attempts to rehabilitate you, deter others from committing similar acts to the sentence of this court, that you be placed on probation for a period of 2 years. Along with the statutory terms of probation has the following specific conditions. You must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must perform 100 hours of community service. If you successfully complete the 100 hours of community service, the court will reduce your fines and costs by $600. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not change your residence unless you first obtain written permission from the field agent. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must be in your approved residence between the hours of 11 p.m. and 5 a.m. unless excused by first obtaining written permission from the field agent. You must not have any verbal, written, electronic, or physical contact with Amanda Tubbs, either directly or through another person. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours a week. You must comply with DNA testing, pay a $60 fee, pay a $68 state cost, a crime victim's assessment of $130, court costs of $500, a fine of $500. How much are you charging for attorney fees, Mr. Diedrich?
Your Honor, that was something I was supposed to mention. I was retained in this matter. There should not be any further.
All right. Probation officers of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, confine a probationer who is in violation of probation condition or who is conducting himself inconsistent with the public good. You're not allowed to purchase, possess, or use anything that contains ephedrine or pseudoephedrine. You're not allowed to use, possess, or purchase recreational marijuana. You're not allowed to associate with anyone you know to use, possess, or purchase recreational marijuana. Are you in substance abuse counseling now, Mr. Dandris?
No, Your Honor.
All right, that's going to be one of the orders. That's when you're do some substance abuse counseling. I think I stated that it'd be determined by the probation officer. But I'm going to make that an order. You must do substance abuse counseling.
Okay.
All right. You are entitled to a appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you. Furnish your attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days sent directly to the court. Court must impose license sanctions, so your license will be suspended for 6 months. A restrictor will be allowed after 30 days. Good luck to you, Mr. Andrews. Get on top of that problem.
Yes, Your Honor.
Your Honor, if I may.
Yes.
Mr. Andreas, do you have a piece of paper and a pen to write down my number?
Yes.
My number is 989-329-9820. You need to contact me between 1 p.m. and 5 p.m. today. Thank you, Your Honor. Nothing further.
Okay.
The other two individuals on Todd's docket have not appeared, Mr. Walker and Mr. Parker. I do not show in the living room.
And let's do Mr. Parker. Find the case of People versus James Scott Parker II.
Thank you, Your Honor. Todd Dietrich appearing on behalf of Mr. Parker.
The probation hearing, do we know where Mr. Parker is?
Your Honor, unfortunately, I've lost contact with Mr. Parker. I have called and left several messages, as well as sent him at least one letter. And also, I think we also sent him an email, but we've not had any response in close to probably over a month now.
All right. Court is going to cancel and forfeit his bond, issue a bench warrant for his arrest. Bond in the amount of $5,000 cash. We will hold off on issuing that bench warrant until Wednesday. Again, contact them and bring them into court. Then we can proceed.
I thank you, Your Honor.
In the case of the people versus Austin Wesley Walker.
Thank you, Your Honor. Todd Dietrich appearing on behalf of Mr. Walker. So, Your Honor, in this matter, I just talked to Mr. Walker last week, and I don't know if he got confused or what happened, but he had stated he had wanted a hearing, and so I told him that that's what we would ask on today's date, but I have not seen him or heard from him this morning. So I don't know if he thought I was telling him that that's all that was going to happen today, but I don't know.
All right. Court will set this up for a hearing. How long do you think it'll take? An hour? Maybe less?
I think less than an hour, Your Honor.
All right. We'll set it for an hour anyways and go proceed from there. And as long as he's continuing to report, then we're not gonna do anything. All right? You've had contact with him. And on the cases, people versus Derek Michael Newell.
Morning, Your Honor. Mark Webb on behalf of the people.
Thank you, Your Honor. Todd Dietrich appearing on behalf of Mr. Newell.
You are Derek Michael Newell.
You have to unmute your microphone, Mr. Newell.
Yes, Your Honor.
Today was set for an arraignment on the new case. How do you wish to proceed, Mr. Dietrich?
Your Honor, if the court, I don't know if the court has the probation violation file as well.
Yes, we do.
All right, so his plan was to plead guilty to the probation violations, as well as we have an agreement in the new file to do a plea in that file. I know Mr. Webb was going to try to get an amended turned in.
All right. What is he going to plead to in the new file?
The new file would be possession of heroin.
Your Honor. Your Honor.
Yes.
That would be possession less than 25 grams of heroin under 333.74032A5. And that's a 4-year.
All right.
I sent an email to our staff to have one prepared, but I'm not sure what the status of it is.
All right, well, we'll go forward today with the plea and an amended can be filed.
Thank you.
You're okay with that, Mr. Dietrich, is that correct?
Yes, Your Honor. Thank you.
All right. Mr. Newell, how old are you?
33, sir.
You raise your right hand and be sworn.
Yes, sir.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Alright. File number 21-006647-FH. You're being charged with possession of a narcotic less than 25 grams. That's a felony. It carries a maximum penalty of 4 years in prison. The minimum is discretionary with the court. You understand that charge, Mr. Newell?
Yes, Your Honor.
All right. And Mr. Diedrich, you've already gone over the information with Mr. Newell?
I have, Your Honor.
And he's waiving the right to have a reading of the information, amended information at this time?
Yes, Your Honor.
And he's continuing the waiver of the preliminary examination, is that correct?
That is correct.
You're also on probation in file number 19-6139-FH. A controlled substance possession of methamphetamine, second or subsequent offense, a felony carries a maximum penalty of 20 years in prison, the minimum discretionary of the court. A 2-count violation has been filed against you. Count 1 is violation of Rule 3. Count 2 is violation of Rule 4. There's one of 3 possible pleas that you may make to these charges, Mr. Newell. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of 3 possible pleas you may make?
Yes, Your Honor.
Answering in file number 21-6647-FH to the charge of possession of a narcotic less than 25 grams. How do you plead?
Guilty, I think. Guilty.
All right. Answering to the charge of count 1 violation of rule number 3 and file number 196139-FH. How do you plead?
Guilty.
And answering to count 2 in that same file, violation of rule 4. How do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be?
Yes, Your Honor. I would like to address bond, though.
All right. Court further informs you that in file number 21-6647-FH, that if your plea is accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial in front of a jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have any that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. You understand these rights?
Yes, Your Honor.
You understand by pleading guilty in that file, you give up each and every one of those rights?
Yes, Your Honor.
Drawing your attention to file number 196139-FH. You understand that if your pleas are accepted in that file, you'll be giving up the following rights. The right to have a contested revocation hearing, the right to be represented by an attorney, the right to a court-appointed attorney if you're unable to afford to hire your own attorney. Mr. Diedrich is representing you in this manner, that the maximum possible sentence could be 20 years in prison. The minimum is discretionary with the court. That you give up the right to appear at a hearing, present evidence, cross-examine witnesses. You give up the right to have the prosecution or probation office establish a violation by a preponderance of the evidence. You give up the right to remain silent and not have that silence used against you during the hearing, and you give up the right to testify at the hearing if you wish to do so and have your testimony considered in the same manner as any other person's testimony. You understand these rights?
Yes, Your Honor.
You understand by pleading guilty, you give up each and every one of those rights?
Yes, Your Honor.
Mr. Webb, what is the plea agreement in the 21-6647-FH?
Your Honor, in exchange for the defendant's guilty plea to the added count of possession less than 25 grams of heroin, I'll dismiss the other counts at sentencing, and we've agreed that there would be no initial incarceration and that his probation would be extended by a year.
Mr. Dietrich, is that your full and complete understanding for the plea agreement in that file?
It is, Your Honor.
And is there a plea agreement in the probation file, Mr. Dietrich?
There is not, Your Honor.
Other than the initial, another 1 year probation added to that file?
Well, that was part of that was the agreement in the first file, but so I guess it would automatically be so in the second file as well.
All right. Mr. Newell, did you hear us put on the record as the plea agreements?
Yes, Your Honor.
Did you understand them?
Yes, Your Honor.
And are you in agreement with them?
Yes, Your Honor.
Has anybody promised you anything beyond what was stated on the record as the plea agreements to induce you to plead guilty?
No, Your Honor.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, Your Honor.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No, Your Honor.
Is it your own personal choice to plead guilty?
Yes, Your Honor.
And are you doing so freely and voluntarily?
Yes, Your Honor.
Do you have any questions about what the court has told you?
I just want to address bond in the probation violation case.
Okay, that'll be at the end.
Yes, Your Honor.
Anything else?
I have also agreed to work with,
Okay, I'll cut you off there.
Thank you.
All right. And,
I don't know what I'm doing here.
Just hang tight for a minute. All right, we're gonna address bond. I know you want to address bond. We're gonna address that here as soon as the judge is ready.
all right. Have you understood everything that the court has told you, Mr. Newell?
Yes, Your Honor.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, Your Honor.
All right. Drawing your attention to honor about the time, around February 26th of 2019. Did you have some heroin in your possession?
Yes, Your Honor.
And you knew it was heroin?
Yes, Your Honor.
And was it less than 25 grams?
Yes, Your Honor. It was very little.
Did you have a license or a prescription
Your
to
Honor,
have
I
that
did
in your
not.
possession?
No, Your Honor.
Prosecutor satisfied the factual basis in that case, or do you have any questions?
I'm satisfied with that factual basis, Your Honor.
Mr. Dietrich, you're satisfied with the factual basis in that case?
Yes, Your Honor.
Is it true, Mr. Newell, that part of your probation was to report to the probation officer monthly or as often as the probation officer may require? Is that correct?
Yes, Your Honor.
And you were supposed to report to the probation officer back on June 18th of 2020, is that correct?
Yes, Your Honor.
And you failed to do so?
Yes.
And part of your probation was to immediately notify the probation department of any changes of address, is that correct?
Yes, Your Honor.
And you failed to report a change of address on or about June 18th of 2020, is that correct?
Yes, Your Honor.
Satisfied with the factual basis in that case, Mr. Dietrich?
Yes, Your Honor.
Has court complied with the court rules, Mr. Webb?
You have, Your Honor.
Has court complied with the court rules, Mr. Dietrich?
Yes, Your Honor.
Court has not agreed upon the possible plea or the possible sentence with either the prosecutor or defendant or anyone acting in the interest of either. Court is convinced the plea is accurate, the pleas have been accurate, freely done, knowingly, understandingly. Pleas are accepted and ordered entered upon the records of this court. Sentencing. Will be set for July 12th at 9:40 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report in the new case and an updated case report in the old case.
Your Honor, I apologize. I'm out of the state at that point in time. Is there a later or earlier date available?
Can we get it done before then, Mr. McConnell?
We probably could, Your Honor.
All right, then we'll move it forward to June 28th at 9:40 a.m. We'll refer Department of Corrections for those reports. To the plea agreement, the court will reduce the bond to a PR bond in the new case. You may address bond in the probation violation case.
Thank you, Your Honor. I guess I'd like to point out to the court that the new case is actually something that had occurred prior to the case that Mr. Newell is currently on probation for. We had a long discussion with Mr. Newell about his responsibility to staying in touch with his probation officer and what his requirements would be, and that if he had questions about those requirements, that he could always ask the probation officer. He does have a new relationship that seems to have a positive influence on his life. He seems to be very vested in trying to do the right things for the relationship and the children involved in the relationship. And, and he and I talked about, part of that's going to be, trying to make sure you're doing all things you have to do in probation so that, probation does not become a hindrance to the relationship, but more of an asset because it's keeping you in line, keeping you, employed, keeping you, from getting in more trouble that ultimately is going to damage that relationship anyway. He advised me that he's in agreement with getting back on track and keeping up with his reporting. And based on that, he has been incarcerated since I believe it was May 6th, approximately, that he was picked up. And so it's almost 3 weeks for the failure to report violations. I would ask the court to consider a PR bond or a minuscule bond to allow him the opportunity to be out until sentencing.
So I can get my affairs in order and strengthen my family, Your Honor. I'd appreciate it. I am in agreement to a GPS tether. I have a little bit of bond money saved up, not very much. I think it's like $200. I am ready to face my facts and to continue on with my life, but I really have a positive spin on this relationship and I'm excited about it and I want to strengthen it before I have to continue my incarceration and pay for my mistakes and continue on with my life. Thank you.
Mr. McConnell, has Ms. Medley met with Mr. Newell since he's been picked up?
I'm not sure, Your Honor. I did receive an email from Miss Medley about Mr. Newell's case. After he was sentenced to the initial term of 12 months in jail, when he was released from jail, he absconded from supervision. He was then sentenced on 1/21 of 2020 to the RAP program. And once again, as soon as he completed the program, Mr. Newell again absconded from probation.
All right, what I'm going to do is I'm going to take this under advisement. I want Ms. Medley to meet with Mr. Newell, and I want her recommendation as to what bond should be.
Yes, Your Honor.
All right, and then I'll make a decision. All right. You're all set, Mr. Newell.
When should I know about bond?
whenever it gets done, Ms. Medley's gonna come and interview you and talk to you, and then she'll make a recommendation to me, and I'll talk with her and we'll decide. All right?
All right, Your Honor, thank you.
All right. I believe that takes care of all your cases, Mr. Diedrich.
It does, Your Honor. Thank you.
Your Honor,
Yes.
that amended information's been completed and should be on its way up.
All right, thank you. Calling the case of People versus Joanne Eileen Hadley.
Yes, sir.
Counsel, identify for the record, please.
Joanne Eileen Hadley.
Sherman Stiles, appearing on behalf of the people.
Karen Tomczyk appearing on behalf of Ms. Hadley.
All right. Today set as a pretrial. Has a pretrial summary been filled out, Ms. Ambrositis?
I'm looking. Gotta give me a minute to get into the case.
Okay.
You know, it doesn't look like we filed a pretrial summary, but the probable cause summary offered OWI 3rd, BK cap 3 months. Tentative guidelines are 0 to 9, and quite frankly, that would be a presumptive probation under the new law with $35 for the blood draw, $100 to law enforcement, and cost of prosecution as established for the prosecutor's office. We would also agree for day credit for any inpatient treatment successfully completed. I'll send the pretrial summary form to the law library printer here in a moment.
It's basically the same offer as the PCC. Any comments, Ms. Tomczyk?
Your Honor, I have discussed that offer with my client. I would note that I don't believe the presumption changes the mandatory minimum 30 days. At this point, she indicates to me she wishes to reject that offer and continue on towards trial.
All right. So continue on the trial docket with a final pretrial and a trial date being set. Anything further?
No, Your Honor.
Ms. Hadley, you may sign off.
Thank you, Your Honor.
Calling the case of the People versus Carrie Ellen Hill Johnson.
She's here in person, Your Honor.
All right, come up to the podium. Counsel, identify for the record.
Sherman Stiles, appearing on behalf of the people.
Karen Tomczyk appearing on behalf of Ms. Hill Johnson.
All right. And you are Carrie Ellen Hill Johnson?
Correct.
Previously, you appeared in court and pled to the charge of police officer assaulting, resisting, or obstructing. That's a felony. It carries a maximum penalty of 2 years in prison. Minimum discretionary with the court. You also pled to the charge of trespass. That's a misdemeanor. Carries a maximum penalty of 30 days. And you pled to the charge of reckless driving, a misdemeanor. Carries a maximum penalty of 93 days in the county jail. Minimums are discretionary with the court on those two. Pre-sentence investigation report has been prepared. Sentencing guidelines on the felony charge are 0 to 6 months. Ms. Tomczyk, have you had an opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Anything of a factual nature that you wish to add to, explain, or controvert in that case?
No, Your Honor.
Any objection to the scoring of the guidelines?
No, Your Honor.
Ms. Ambrositis, on behalf of the people.
Your Honor, we've had the opportunity to review the pre-sentence investigation report. We do find it to be factually accurate. We've had the opportunity to review the prior record variable scoring and the offense variable scoring, and we find those to be accurate as well.
Ms. L. Johnson, is there anything you wish to say to the court before the court passes sentence?
Your Honor, I am a single mom. I take care of my mother. I take care of my children. I work 2 jobs, and I just need to stay away from the law.
Ms. Tomczyk, on behalf of the client?
Yes, Your Honor, this, I think, Ms. L. Johnson wrote a very long and detailed, account of her, how she perceived this, incident to have happened, Your Honor, and I think, I would say that, the officers did, discuss with her at length and tried to do, the best they could. I also don't think that, at least in Ms. Hill Johnson's perspective, that she was given a very clear kind of ultimatum to leave or remain there. I think this has a lot to do with Mr. Davis and his lies that he told to Ms. Johnson. She does understand that, she is now going to have a lot of things, and this is going to have a very big impact on her life, Your Honor. Ms. L. Johnson indicated to me that she would ask for costs and fines only. She believes that with her job and being a single mother and everything, that probation will be very difficult for her. But Your Honor, obviously, Ms. L. Johnson does not want to go back to jail.
Ms. Ambrositis, on behalf of the people?
Your Honor, we ask that you follow the plea agreement and the recommendations in this case.
Are there any victims present that wish to speak to the issue of sentencing? Let the record reflect there are no victims present either in the courtroom or on Zoom. Court has reviewed through the pre-sentence investigation report. Does provide for sentencing guidelines of 0 to 6 months. In order to punish you for what you have done, to attempts to rehabilitate you, to deter others from committing similar acts, protection of the community, is the sentence of this court that you be placed on probation for a period of 6 months. Along with the statutory terms of probation have the following special conditions. You must not use or possess alcoholic beverages or other intoxicants, or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia, or be with anyone you know to possess these items. You must use prescription drugs only as prescribed for you by your licensed physician. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must complete counseling following assessment by a qualified community-based service provider. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have a verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must pay $168 in state costs, comply with DNA testing, pay a crime victim's assessment of $130, pay a supervision fee of $30 a month, pay court costs of $300, a fine of $200. How much are you charging for attorney fees?
$740.
$740 in court-appointed attorney fees. Probation officer of this court or any other supervising agent may pursuant to MCL 771.4 apprehend, detain, confine a probationer who is in violation of probation condition or who is conducting himself inconsistent with the public good. You must not use, purchase, or otherwise possess recreational marijuana or be in the home or company of anyone who uses or possesses recreational marijuana. You must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from your field agent. You must set up an installment payment agreement with the Clare County Clerk's Office within 30 days for the payment of these fines and costs. Mr. McConnell, any questions or information for Ms. Hill Johnson?
Yes, Your Honor. Ms. Hill Johnson, do you have something to write with? Take out another phone number.
No, I don't.
Okay, just go ahead and reach out to Agent
We'll
Medley.
make a note for her. We'll make a note for her.
Thank you, Your Honor.
Go ahead.
She needs to contact Agent Brubaker at 989-423-9411 by the end of today. Thank you, Your Honor.
All right. Good luck to you, Ms. Hill Johnson. You're all set.
Just a right here, and I don't see Miss Matthews on, I wanted to
Okay.
make sure. It looks like she already has a warrant, so I doubt that this is her.
Good morning. Would the person with the telephone number ending in 357 please identify yourself to the court? Telephone number ending in 357, please unmute your microphone and identify yourself to the court.
That's the only one in the waiting room.
There's other people in the waiting room, the only one that I don't know who it is. I just want to make sure it's not Allison Matthews before we move on to the case.
All right.
Telephone number ending in 357, please unmute your microphone and identify yourself to the court.
Apparently that's not me. Okay, in the waiting room, we do not have Allison Matthews.
Calling the case of people versus Allison Lorraine Matthews. Counsel identify for the record, please.
Sherman Versailles, appearing on behalf of the people.
And Tom Chick appearing on behalf of Ms. Matthews.
Ms. Tomczyk, have you had any contact with Ms. Matthews lately?
Not, Your Honor.
All right. Well, she failed to complete the PSI packet and the bench warrant was issued for her arrest. So we will not schedule anything in this case until she's picked up.
Your Honor, is there a bond out on the bench warrant?
Yeah, there's already one been issued, 25,000 cash.
Thank you, Your Honor.
In the case of people versus Sean Lynn Colson. Counsel identify for the record, please.
Sherman Versailles, appearing on behalf of the people.
Karen Tomczyk appearing on behalf of Sean Colson.
And do we have Sean Colson present?
We do it still connecting to audio though.
Wait for her to connect. Tomczyk, have you had contact with Ms. Colton lately?
I have, Your Honor.
She failed to return her PSI packet. You know that?
I found that out when I got the case report on Thursday, Your Honor. I had contact with Ms. Colton earlier in the week, and I had set an appointment for her on Friday when I likely received the PSI, but then I get this case report. I had contact with her on Friday. We discussed the fact that, or the case report, Ms. Colton indicated to me that she had called Agent Scott Coder on April 13th or 14th. He indicated to her that she needed to call the office. She called the office that day, left a message with them. She states that she is unsure as to why, but she says she never got that voicemail that Agent Brubaker left. I would note to the court that Ms. Colton is also involved in a neglect and abuse matter. And I've spoken with the Department of Health and Human Services, Nicole Herring. She indicates to me that she has never had a problem getting a hold of Ms. Colton. She was kind of surprised to hear that she didn't return this message, but would also note that per CPS worker, Nicole Herring, that if Ms. Colton were to return to jail, that her son would likely have to enter foster care and would likely be placed in a residential placement. So, Your Honor, in this, I've given Ms. Colton, Ms. Brubaker's phone number, her direct phone number. I have also confirmed with Ms. Brubaker that she has the correct number for Ms. Colton. So I would ask that the court allow Ms. Colton one more opportunity and to get this PSI packet done.
Ms. Colton, can you hear us?
It's still saying she's not connected.
All right, she's having trouble connecting here today. So what I'm gonna do is I'm gonna adjourn the sentencing to June 28th at 10 a.m. If Ms. Colton doesn't have that PSI packet filled up and given to Ms. Brubaker by Friday at 5 o'clock, then Monday we will issue a bench warrant for her arrest, bond in the amount of $25,000 cash. So Ms. Tomczyk, do your best to get her on the right track.
I will do that, Your Honor. Thank you.
All right.
What timeline did you give her, Judge?
For what?
For completing the PSI?
Friday at 5.
Friday, thank you.
Calling the case of People versus Amy Elizabeth Harsh.
Morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Karen Tomczyk on behalf of Ms. Harsh.
And Ms. Harsh, are you present on Zoom?
She is muted.
Can you unmute, Ms. Harsh?
I just unmuted, Your Honor.
All right. You are Amy Elizabeth Harsh?
Yes, Your Honor.
Previously, you appeared in court, pled to the charge of controlled substance possession of methamphetamine, a felony. It carries a maximum penalty of 10 years in prison. The minimum is discretionary with the court. Pre-sentence investigation report has been prepared. So sentencing guidelines have been determined to be 0 to 9 months. Ms. Tomczyk, have you had an opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Anything of a factual nature that you wish to add to explain or controvert?
No, Your Honor.
Any objection to the scoring of the guidelines?
No, Your Honor.
Mr. Webb, on behalf of the people, anything regarding the court report or guidelines?
Your Honor, I have reviewed the report. I have no additions or corrections to make to it, and the guidelines are correct this court.
Ms. Harsh, is there anything you wish to say to the court before the court passes sentence?
I would just like to take this time to apologize to you and everybody else for my stupidity. And I have learned a very, very valuable lesson from this.
Ms. Tomczyk, on behalf of your client?
Yes, Your Honor, as the court can see from the court report that this is Ms. Harsh's first drug conviction, and we would ask that the court grant her the 7411 status, Your Honor. It can be shown, I think this is one of those cases where luckily Ms. Harsh was caught early in her use of the heavy and methamphetamines and amphetamines, Your Honor. She's back on the right track, doing what she needs to do. We would just, like I said, ask that she be given the opportunity to keep this off of her record. She understands what a great benefit that is and would not mess that up, and that she be allowed to show the court that she is not the individual that committed this crime, and this is kind of a one-time incident for her.
Mr. Webb, on behalf of the people.
Your Honor, I just ask you to follow the plea agreement and the recommendations.
Court has reviewed through the pre-sentence investigation report. Does provide for sentencing guidelines of 0 to 9 months. In order to punish you for what you've done, to attempt to rehabilitate you, deter others committing similar acts, will be the sentence of this court that you be placed on probation for a period of 18 months under the 7411 statute. Along with the statutory terms of probation, you're going to have the following special conditions. You must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must attend AA, NA, or CA meetings at the frequency required by the field agent. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must perform 100 hours of community service. If you successfully complete those 100 hours, the court will reduce your fines and costs by $600. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have a verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must make genuine efforts to find and maintain legitimate employment of minimum 30 hours a week. You must comply with the NA testing and pay a $60 fee. You must pay a $68 state cost. Pay a crime victim's assessment of $130, court costs of $500, a fine of $500, and attorney fees. How much are you charging for?
Your Honor, I have $360, but I would also like to make the court aware that Ms. Harsh does have a valid medical marijuana card that she will be supplying to the probation agent.
All right. $360 court-appointed attorney fees. Probation officer of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, confine a probationer who is in violation of probation condition or who is conducting herself inconsistent with the public good. You're not allowed to use or otherwise possess recreational marijuana or be in the home of anyone who uses recreational marijuana. You must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from your field agent. You must set up an installment payment agreement with the Clare County Clerk's Office within 30 days. And you must pay a $30 supervision fee if the Department of Corrections decides to put you on electronic monitoring, that fee would be increased to $60 a month. Do everything you said, say the court tells you to do, the probation department tells you to do, good things happen and you won't have a felony record. If you fail to follow all the rules, you're gonna come back in front of this court for sentencing again. So make sure you comply with everything, Ms. Harsh. Mr. McConnell, any questions or information for this person?
Yes, Your Honor, thank you. Ms. Harsh, you need to contact Agent Brubaker by the end of business today.
Okay,
Thank you, Your Honor, that's all.
All right, you're all set, Ms. Harsh. Good luck.
thank you, Your Honor.
You can sign off, Ms. Harsh.
Thank you.
Calling the case of People versus Brandon James Ballas.
Sherman Besides, appearing on behalf of the people.
Aaron Thompson, appearing on behalf of Mr. Ballas.
You are Brandon James Ballas?
Yes, Your Honor.
And you're currently on probation and breaking and entering the building with intent plus habitual criminal offender second. That makes that a felony with the maximum penalty of 15 years in prison. You're also on probation for larceny of $1,000 or more, but less than $20,000 plus habitual criminal offender second. That makes that a felony with a maximum penalty of 7.5 years in prison. A 4-count violation has been filed against you. This was just said as a status conference, Ms. Tomczyk. How do you wish to proceed?
Your Honor, I've spoken with probation agent Medley, and she indicated that if Mr. Ballas would plead to counts 1 and 2, she was recommending the RAP program. She would be dismissing counts 3 and 4. I have discussed that with Mr. Ballas, and he would like to accept that offer.
All right. Mr. Ballas, how old are you?
31.
You raise your right hand and be sworn.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Count 1 is violation of Rule 3. Count 2 is violation of Rule 4. There's one of 3 possible pleas you may make to these charges, Mr. Ballas. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stay on mute, in which event the court will enter a plea of not guilty for you. You understand the one of 3 possible pleas you may make?
Yes, Your Honor.
Answering the count 1, violation of Rule 3, how do you plead?
Guilty.
Answering the count 2, violation of Rule 4, how do you plead?
Guilty.
You understand that if your pleas are accepted, you will not have a hearing of any kind and therefore give up the following rights. The right to have a contested revocation hearing, the right to be represented by an attorney, the right to a court-appointed attorney. If you're unable to afford one, Ms. Tomczyk is representing you on this matter, that the maximum possible sentence could be 15 years in prison. The minimum is discretionary with the court. That you give up the right to appear at a hearing, present evidence, cross-examine witnesses. You give up the right to have the prosecution or probation office establish a violation by a preponderance of the evidence. You give up the right to remain silent and not have that silence used against you during the hearing. Give up the right to testify at the hearing if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. You understand these rights?
Yes, Your Honor.
You understand by pleading guilty, you give up each and every one of those rights.
Yes.
But has anyone promised you anything beyond what was stated on the plea agreement to induce you to plead guilty?
No, sir.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, sir.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No, Your Honor.
Is it your own personal choice to plead guilty?
Yes, Your Honor.
And are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, Your Honor.
Have you understood everything that the court has told you?
Yes.
In light of everything that the court has told you, you still wish to plead guilty?
Yes.
And part of your probation was to make a truthful report to the probation officer monthly or as often as the probation officer may require, either in person or in writing. Is that correct?
Yes.
And is it true you were supposed to report to the probation officer on or about February 4th of 2021?
Yes.
And you failed to do so, is that correct?
Correct.
And part of your probation was to notify the probation officer immediately of any change of address or employment, is that correct?
Yes, Your Honor.
And you changed your address, is that correct?
I tried to change my address and it actually, the transfer got denied, so it just got pushed back to my original address, I guess.
So then you failed to change your address with, or you changed your address without permission, is that correct?
I basically just absconded after the transfer got denied.
All right. Court finds a factual basis for the plea. Has the court complied with the court rules?
Yes, Your Honor.
Court is satisfied the plea is understandably, voluntarily, and knowingly made. The plea is accepted and ordered entered upon the records of this court. You wish to go to sentencing today, Ms. Tomczyk?
Oh, well, Your Honor, I've discussed with Mr. Ballas, and I don't, if the court would be open to allowing Mr. Ballas to try to find his own treatment facility. He would like time to get that set up. If not, then he would waive and ask that we go to sentencing today.
All right, so basically, we're gonna order him to the RAP program. That's a residential place, isn't that correct, Mr. McConnell?
It is correct, Your Honor.
All right. So he's waiving the right to have an updated case report, Ms. Tomczyk?
Yes, Your Honor.
All right. Mr. Ballas, is there anything you wish to say to the court before the court passes sentence?
No, Your Honor.
Ms. Tomczyk, on behalf of your client.
Yes, Your Honor. I had a long discussion with Mr. Ballas, and he recognizes that he has a substance abuse problem, and that's the root of everything that's going on, Your Honor. Why he's absconding, why he's not reporting. So he's looking for treatment, Your Honor, and we understand that the RAP program offers that. We would ask that you send him to that to allow him to get treatment and address his substance abuse issues, Your Honor.
In order to punish you for what you've done, to attempts to rehabilitate you, deter others from committing similar acts, protection of the community, the sentence of this court is that you'll be continued on probation with all its original terms. You're going to be sentenced to the RAP program. Mr. McConnell, will he need to provide his own transportation, or is the department going to provide transportation for him?
Your Honor, the department will provide transportation.
All right. So you'll be continued in jail until they can provide transportation to the RAP program. You'll get credit for all time served at this point. How much are you charging for attorney fees?
$270, Your Honor.
And you'll be charged an extra $270 for court-appointed attorney fees. You are entitled to appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of an appellate attorney must be made in writing within 42 days, sent directly to the court. Please sign the notice of appellate rights form when it's presented to you. Bond is canceled. Handed to the custody Department of Corrections for carrying out the sentence. Court will note that the original sentencing guidelines were 5 to 28 months. You're all set, Mr. Ballas. Good luck to you.
Your Honor. I had a question.
Yes.
Is there, if I could ask you, possibly Nate McConnell, I had a quick question. I was gonna see if I could possibly get, if I had my fines paid off before the completion of the RAP program, if I could possibly get a unsuccessful discharge off probation.
Probably not at this time. I'd have to review that with the probation officer in charge to make that decision.
Okay,
All right.
thank you.
Believe that takes care of all your cases, Ms. Tomczyk?
I believe it does, Your Honor. Thank you.
Ms. Tomczyk,
Yes?
do you know if Mr. Santini will be appearing? I don't see him in my waiting room, and he was just recently reassigned Seneca Cybert's cases, which are next.
I will remind him real quick.
Okay, thank you. Mr. Cybert's in the jail, so it's gonna take a moment for them to swap out.
Okay.
And, Mr. Santini still has the log on.
Do we have Mr. Rowe available?
Yes, we do.
I'm here.
All right.
I don't show that, I show the only person that we have on for Mr. Rose so far is Miss Stanford John Adams.
Okay. Well, let's call this case.
Okay.
Calling the case of the people versus Stanford John Adams.
Your Honor, Austin R. Rowe, attorney on behalf of Mr. Adams.
Chairman Presiding, speaking on behalf of people.
You are Stanford John Adams. Can you hear us, Mr. Adams?
It's still showing connection.
All right.
I don't know if it's us or.
There's an offer of proof in the file. Is this going to be a plea, Mr. Rowe?
Yes, it will be, Your Honor.
Count one, and then count two will be dismissed.
Yes, Your Honor.
Your Honor, it's to an added count, attempt assault with a dangerous weapon.
Okay.
BK no initial incarceration.
All right, I see that count two is an attempted assault. All right. Mr. Adams, can you hear us?
It's still showing he's connecting. Is count two the added count?
Yeah.
Okay. He is now connected. He just needs to unmute his microphone.
Can you hear us, Mr. Adams? If so, unmute your device.
Yes, I can hear you now.
All right. And you are Stanford John Adams.
Right.
And how old are you?
67.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And Mr. Rowe, you've gone over this amended information with your client?
Your Honor, we briefly talked about that, but I do think we need to talk. Mr. Adams, I sent him a copy of the offer of proof, but I have not yet talked with him on that.
All right, so you'd like a breakout room for a little bit?
Yes, please.
All right, we'll put you in the breakout room. The court will take a recess.
All right.
Give me just one moment. I'll place you and Mr. Adams in a breakout room. Okay, I'm gonna go ahead and place you in there now.
All right, thank you.
If there's Mr. Colton, really, if I can get him to connect.
What you got? This pickup guy is a Judge Evans case. Judge Evans wants to do it and have a judgment. Give this to Steve, sir.
And just let Deb know.
Ms. Cole, can you unmute your microphone? Hi, Ms. Cole. Who are you here appearing for?
Yeah. Can you hear me?
I can hear you. Who are you? What case are you appearing for today?
I don't remember the case number. It was for a charge for possession of methamphetamine.
Kelly Bailey.
What is your name?
It's Kelly Cole, Kelly Beatty.
Okay, thank you. It just came up differently. Okay, give me just a moment. Your case hasn't been called yet, but I've been placed in the waiting room, and as soon as they call your case, I'll bring you back in, okay?
All right, thank you.
Thank you.
Shopping at the Walmart while you're.
She works there.
So which is that better? That she's at work at Walmart?
It's like walk around.
Ms. Cole,
Give me just 1 second, sorry.
Ms. Colton, unmute your microphone, please. Can you hear me?
Yeah.
Okay, your case has already been handled.
Okay.
You were unable to connect earlier. We were having problems getting you connected. So I would recommend contacting your attorney and or the Agent Brubaker, I do believe.
Yes.
So I recommend contacting both of those individuals to find out what you need to do prior to your next court date, okay?
Okay, thank you.
Thank you.
Hey, Stacy,
Yeah.
I printed the pretrial summary for Mr. Adams to the law library.
Get the pretrial Sunday, but she'll just print it off the printer and have judge sign those.
Alright, I'm gonna have Dietrich going back off for that. If the judge opens case. But he wants judge to put random on the failure to appear warrant.
Okay.
So I'm gonna call Dietrich and tell him to log back on, yeah.
Okay.
I have to step away from my computer for a moment.
Okay.
I did call the prosecutor's office too, so.
Okay, perfect. Thank you, Christina. Is Copley incarcerated?
Yeah.
Okay. This is why it's confusing me, because I did go through these beforehand. And what about C,
No,
Jennifer?
no.
And
Russell is.
Russell is?
Yeah.
Okay, he's,
Okay.
he wants this here.
And I still don't see
He's looking
Santina
at
in there.
everything, and he said that if we could talk to him, yeah, and then get him into the jail, then we can just arraign him, because you can't.
Is here, he's in jail?
Yeah, they just arrested him.
Okay.
Who is it?
Well, we have
Chuck.
Seibert, Tierbin, Cobley. Is Paul Smith in there?
No. Bradley Orr.
Paul Smith is at TRICAP.
Okay, and what about, you said Orr is over in CCSD?
Yep.
Okay. That'll help me navigate the rest of them, because a lot of people, and then Eric Heron is obviously at CCSD.
We're doing him again.
I guess. Okay,
So you want Shrek before Cyber, or you want?
Do we
well, I
have Mr.
feel
St.
really
James?
bad because we have Mr.
Melton.
Butcher from Triton Legal that has been on for quite some time now, waiting, and he only has one case, and his client is over in the sheriff's department.
Yeah.
Hey, Stacy,
Awesome. Sorry, go ahead.
did you need Brandon Ballas's credit?
Yes.
I got 376 days.
Peggy, before we give those back.
Is that Ballas?
Yeah.
Yeah,
Before we
so
give
I just
those
asked Kelly for it.
back, can we write that on the thing? 376, you said?
That's correct.
Thank you.
You're welcome.
All right, Your Honor, he's got it.
So, I hate to do this, but if they have cyber already pulled, I still don't have Andrew Santini. Is there a possibility to have them pull Bradley Orr? He just got a pretrial hearing. They can pull him, I can get Mr. Triton Legal and that one done fast. Austin, would that be all right?
What's that?
I have Mr. Butcher from Triton Legal, and Mr. Orr is incarcerated. Would it be all right just to do that pretrial really quickly, before we move on to all of your cases?
Sure.
Thank you.
Corrections from court. Cyber's attorney has not shown up yet, so can we, get him out of there and bring up Bradley Orr, please?
Okay, were there more signed temps, or did she take them back for judge to sign?
They're back there with judge's side, and here is, in case it's not on the temp order, we've ready for their copy for ballast, it's 376. It's his credit, so that's his time. I didn't even put PS in the thing.
Just
needs to
blank,
be put
okay.
in.
Ballast, okay.
Good morning, Mr. Butcher.
Boucher, I'm here, thank you.
Touche, I apologize.
Nothing.
We are bringing your client over right now, to the sheriff's department Zoom room. So if you'll give us just a moment, we will get you out of the way. Thank you for being patient.
Oh, it's not a problem, no apologies needed, thank you.
Oh, no, I won't. You'll have to text him to come.
I will.
Oh, no, I won't.
All right. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
May be seated.
I think I'm still waiting for the defendant to be brought.
Okay. Calling the case of the People versus Bradley Orr. Counsel identified for the record.
Good morning, Your Honor. Mark Webb on behalf of the people.
May it please the court, Matthew Boucher on behalf of Bradley Orr, who is going to be present from the Clare County Sheriff Department Jail.
All right. This is set as a pretrial. A pretrial summary has been forwarded to the court. Mr. Boucher, have you received that?
I have, Your Honor.
Did you have an opportunity to talk that over with your client?
No, Your Honor, I did get it end of last week. I have not been able to schedule a meeting with my client. I do believe we're gonna have a resolution on this matter. My thoughts for today, and I'll leave it to Mr. Webb to address as well, is maybe set this for a plea date or a final pretrial, allow myself a chance to make sure that I've scored this and spoken with my client and we're ready to proceed.
Okay.
That's fine with me.
Would you like that set before the end of June or?
Your Honor, I don't think I need much time, but I hate to ask for 2 or 3 weeks. I think 30 days would be more than appropriate, and there should be no issue with being
I
ready
can
to.
put you on for June 14th or June 28th.
One honor, Your Honor, or one moment, Your Honor. June 14th. Your Honor, the 28th would be better for me. I'm wide open. I've got a trial on the 14th.
Okay. All right. And you are Bradley James Orr? Can you hear us, Mr. Orr?
He's done.
You need to unmute. Mr. Orr, can you hear us?
Yes, sir.
All right. So they would said as a pretrial summary has been forwarded to the court. The court has signed that. Mr. Brochet has a copy of it. And we're going to set a status conference for June 28th at 11 o'clock. Set it for 11 o'clock. And Mr. Brochet, you're going to set up an appointment to meet with Mr. Orr later?
Yes, Mr. Orr, what the court's indicated is we have some new documents that I need to discuss with you. I'll be setting up a Zoom meeting with you, and we will go through those so that we can proceed appropriately. Okay?
Okay.
Anything else?
Nothing on my end. Thank you, Your Honor.
I have nothing additional, Your Honor. Thank you.
All right, thank you. And Mr. Orr, you're all set.
I'll be in contact with you this week, Mr. Orr.
Okay, thank you.
You're welcome. Thank you, Your Honor.
We have Mr. Adams and Mr. Rowe back in.
Okay. Recalling the case of People versus Stanford John Adams. And Mr. Rowe, you've had some time to talk with Mr. Adams?
Yes, I have, Your Honor.
All right, and is he ready to go forward with a plea, or?
I believe we are ready to proceed with the plea with a no contest plea according to plea bargain, Your Honor.
All right. We already swore Mr. Adams in, correct?
Yes.
All right. And so Mr. Rowe, you've gone over the amended information with Mr. Adams, is that correct?
That's correct, Your Honor.
And is he waiving the reading of the amended information for today's purposes?
Yes, Your Honor.
And he's continuing his waiver of preliminary examination, is that correct?
That's correct, Your Honor.
Mr. Adams, you're being charged with count 2, attempted assault with a dangerous weapon. That makes that a felony with a maximum penalty of 2 years in prison and/or $1,000 fine. Minimum is discretionary with the court. Do you understand the charge and the possible penalties, Mr. Adams?
Yes.
All right. There's one of 4 possible pleas you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty. You may stay on mute, in which event the court will enter a plea of not guilty for you, or you may plead no contest, which means you will not contest the prosecutor's offer of proof, and it amounts to a plea of guilty. You understand the one of 4 possible pleas you may make?
Yes.
Answering to count 2, attempted assault with a dangerous weapon, how do you plead?
No
No
contest.
Mr. Adams, how do you plead?
No contest.
All right. You understand that no one may make any promises for this court as to what your sentence will be?
Yes.
Court further informs you that if your plea is accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent, not have that silence used against you during trial, and the right to testify at trial if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes.
You understand by pleading no contest, you give up each and every one of those rights.
Yes.
What is the plea agreement?
Your Honor, return for the defendant's guilty plea to count, or no contest plea to count 2 in the amended felony information, the people would move to dismiss the remainder upon sentencing and running the appropriate appeals period. Furthermore, there is an agreement pursuant to Briggs and Killebrew that there would be no initial incarceration. Restitution is to be determined to William Pulliam II and is made part of this agreement. Remainder is dismissed.
Mr. Rowe, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Adams, did you hear what was put on the record as the plea agreement?
Yes,
Did you understand it?
yes,
And are you in agreement with it?
yes,
Has anyone promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
no,
Or no contest, I meant. Does anyone threaten you or your family in order to induce you to plead no contest?
no,
Has anybody promised you that if you pled no contest, this court would be lenient upon you in any way?
no,
Is it your own personal choice to plead no contest?
yes,
And are you doing so freely and voluntarily?
yes,
Do you have any questions about what the court has told you?
no,
Have you understood everything that the court has told you?
yes,
In light of everything that the court has told you, do you still wish to plead no contest?
yes,
Mr. Rowe, the reason for the no contest plea?
Your Honor, the reason is to avoid civil liability.
All right, that's an acceptable reason. Court has reviewed the offer of proof, finds a factual basis for the plea. Has court complied with the court rules, Ms. Ambrositis?
Yes, Your Honor.
Has court complied with the court rules, Mr. Rowe?
It has, Your Honor, and Mr. Adams and I would ask that you would include our signatures, or at least as part of the record, onto that offer of proof, Your Honor.
All right. Court has not agreed upon the possible plea or the possible sentence with either the prosecutor, defendant, or anyone acting in the interest of either. Court is convinced the plea is accurate, has been freely, voluntarily, understandingly, and knowingly made. Plea is accepted and ordered entered upon the records of this court. Sentencing will be set for July 12th at 10:40 a.m. or 10:20 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is continued. Mr. McConnell, any questions or information for Mr. Adams?
Yes, Your Honor. Thank you. Mr. Adams, do you still reside at 5396 Briarwood?
yes.
And what is your current phone number, sir?
989-487.
Thank you. You'll have a PSI packet mailed to you. Follow the directions when you get that packet in the mail. Thank you, Your Honor. Nothing further.
You're all set, Mr. Adams. You can sign off.
All right.
What do we have in the?
Mr. Seibert and Mr. Santini is here.
All right. On the case of the People versus Seneca Allen Seibert. Counsel identify for the record, please.
Thank you, Your Honor. Andrew Santini on behalf of Ms. Seibert.
And you are Seneca Allen Seibert?
Yes, sir.
All right. And you're on probation in 3 files. Probation violation has been filed in each file. Have you received copies of those, Mr. Santini?
I have not, Your Honor.
All right.
If I can inquire briefly of my client, Mr. Seibert, how long are you going to be sitting in the jail for?
Probably a good minute, depending on my bonds.
Okay. Your Honor, this case came to me from, I think there was a conflict. Mr. Seibert was previously appointed Mr. Moore, and then the file came to me, and I have not received anything on it, and I apologize for the delay. We don't even have a notice of hearing today, so
Okay.
we don't have anything at this point. So I guess we would be asking for an adjournment from the court at this point.
All right, so he's waiving the right to a hearing within 14 days.
Yes, Your Honor.
Okay. Got 3 cases. There's a summons count violation in each case. 2 of the cases have bond at PR bond. The one case has a bond at $2,000 cash, defendant's name only. Do you want this set within 2 weeks?
Please, even next week, if the court can fit it on its docket. I'm not.
We can probably, if you want to call Ms. Reppert, and she could probably put this on the docket next week sometime.
Okay, I can do that.
Hopefully you'll have all that information and be able to go forward.
Yes, that would be helpful.
We'll just set it for a status conference for next week sometime, okay?
That sounds appropriate. Thank you.
All right, you're all set.
Thank you.
Thank you, Mr. Seibert. You're all set.
Thank you, sir.
We have Kelly Beatty.
We could get Russell.
Ross.
Okay. Calling the case of People versus Kelly Joanne Beatty.
Your Honor, Austin R. Rowe appearing on behalf of Ms. Beatty.
Morning, Your Honor. Mark Webb on behalf of the people.
You are Kelly Joanne Beatty. Can you hear us, Miss Beatty?
I can hear you now.
All right. This was set as an arraignment. How do you wish to proceed, Mr. Rowe?
Your Honor, Ms. Beatty waives the reading and she pleads not guilty.
All right. Not guilty pleas will be entered on behalf of the defendant. This will be set on the trial docket with the pretrial being scheduled next. Ms. Beatty, keep in touch with your attorney to find out when the next court date is. You're all set, Ms. Beatty.
Thank you, Your Honor.
I have a phone number that's not attached to anybody. I'll give you some of that.
Can you please identify yourself to the court? Telephone number ending in 357. Can you please identify yourself?
Jennifer Seahigh.
All right. Calling the case of People versus Jennifer Joy CI. Counsel identify for the record, please.
Good morning, Your Honor. Mark Webb on behalf of.
Your Honor, Austin R. Rowe appearing on behalf of Ms. CI.
All right. And you are Jennifer Joy CI?
Yes, Your Honor.
All right. This is an arraignment. Mr. Rowe, how do you wish to proceed?
Your Honor, Ms. Seahigh waives the reading and she pleads not guilty.
All right, not guilty pleas will be entered on behalf of the CI, and this will be set on the trial docket with the pretrial being scheduled next. The CI, keep in touch with Mr. Rowe to find out when their next court date is, okay?
Yes, Your Honor.
All right, you're all set, you can sign off.
Thank you.
Mr. Rowe, have you had any contact with Mr. Cobley?
He's in the Clare County Jail, Your Honor.
Okay, all right.
And then bring it back in to see if we brought it over yet.
Mr. Turbin's in the jail too, Your Honor, and.
Okay,
I
whoever
understand.
they bring in next, will do.
He's on his way.
We do have Mr. Moore but then the defendant I'm sorry, Mr. Diedrich, but the defendant is also incarcerated, so we have a lot of jail.
There's 3 people in jail.
How about Mr. Smith? Have you been in touch with him, Mr. Rowe?
Yes, I have, and as I understand it, he's still at TRICAP right now.
All right. He's not zoomed in at all.
No.
Okay, this is just set as a status conference. Do you want another status conference set out about 45 days?
For Mr. Smith?
Yes.
Yes, please.
All right. Mr. McConnell, how long is the TRICAP program generally?
I believe, Your Honor, it's 90 to 120 days, and I believe that Mr. Smith has been there for almost 30.
Okay, so maybe we should set that status conference out about 90 days.
That sounds about right, Your Honor.
All right, we'll set it up 90 days. We have Mr. Herron or anything? Or his client?
I believe we have Mr. Traven.
Okay. Going the case of People versus Russell Dwayne Traven.
Your Honor, Austin Rowe appearing on behalf of Mr. Thurman.
Good morning, Your Honor. Mark Webb on behalf of the people.
And you are Russell Dwayne Traven? You need to unmute. You're Mr. Traven?
Yeah, Mr. Turbin.
Okay, Turbin, all right. This is set as an arraignment. How do you wish to proceed, Mr. Rowe?
Your Honor, Mr. Turbin's been offered a plea bargain. You'd like to accept that at this time.
All right. And what is the plea offer?
Your Honor, he is to plead guilty to count 1, and count 2 would be dismissed among other terms of it.
All right. Mr. Ryman, how old are you?
36 years old.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And Mr. Rowe, you've gone over the information with Mr. Turbin?
I have, Your Honor.
And is he waiving the reading of the information for today's purposes?
He is.
And he's continuing his waiver of preliminary examination, is that correct?
That's correct, Your Honor.
Mr. Turbin, you're being charged with count 1, controlled substance possession of methamphetamine, a felony that carries a maximum penalty of 10 years in prison and or a $15,000 fine. Unless sentenced to more than 1 year in prison, the court shall impose license sanctions. Otherwise, the minimum is discretionary with the court. You understand the charge and the possible penalties?
Yes, I do.
There's one of 3 possible pleas you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of 3 possible pleas you may make?
Yes.
Answering the count 1, controlled substance possession of methamphetamine, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be?
Yes, I understand.
The court further informs you that if your plea is accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order any witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during the trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
I do.
You understand by pleading guilty, you give up each and every one of those rights.
I do, Your Honor.
Mr. Webb, what is the plea agreement?
Your Honor, it's my understanding that in exchange for the defendant's guilty plea to count 1, possession of methamphetamine, I will dismiss count 2 at sentencing. There is a Briggs Killebrew agreement as to no initial incarceration and then a term of probation.
Right. Mr. Rowe, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Turbin, did you hear what was put on the record as the plea agreement?
Yes, Your Honor.
Did you understand it?
Yes, I did, Your Honor.
And are you in agreement with it?
Yes, I am.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, Your Honor.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No.
Is it your own personal choice to plead guilty?
Yes, Your Honor.
And are you doing so freely and voluntarily?
Yes.
Do you have any questions about what the court has told you?
No.
Have you understood everything that the court has told you?
Yes, I have.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, I do, Your Honor.
Drawing your attention to on or about May 6th of 2021, were you in Freeman Township, Clare County, Michigan?
Yes.
And did you have in your possession some methamphetamine?
Yes, I did.
And you knew it was methamphetamine?
Yes.
And did you have any license or prescription to have that in your possession?
No.
Prosecutor satisfied with the factual basis?
Yes, Your Honor.
Mr. Rowe, are you satisfied with the factual basis?
Yes, Your Honor.
Has the court complied with the court rules, Mr. Webb?
Yes, Your Honor.
Has the court complied with the court rules, Mr. Rowe?
It has, Your Honor.
Court has not agreed upon the possible plea or the possible sentence with either the prosecutor or defendant or anyone acting in the interest of either. The court is convinced the plea is accurate and has been freely, voluntarily, understandably, and knowingly made. Plea is accepted and ordered entered upon the records of this court. Sentencing will be set for July 12th at 10:40 a.m. Defendant is, or 10:20 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Did you want to address bond, Mr. Rowe?
Yes, I would, Your Honor. Mr. Turbin has been in jail, not being able to get out of jail on bond. He's just entered a plea in which he would have no further incarceration. He asked the court to amend his bond to a personal recognizance bond, Your Honor.
Any objection, Mr. Webb?
No, Your Honor.
All right, bond will be amended to the PR bond, $10,000 PR bond. Case is adjourned to the date time set for sentencing. Mr. McConnell, any questions or for Mr. Turbin?
Yes, Your Honor, thank you. Mr. Turbin, what address will you be going to once you're released from jail?
I'll be going to.
Thank you, Your Honor. That's nothing further.
In view of that, Mr. Rowe, do you want to have the sentencing set out about 90 days?
Yes, Your Honor.
All right, we'll move the sentencing out farther. What if we move it to September 13th at 10:20 a.m., okay?
I apologize, Your Honor. What was that date? September?
September 13th at 10:20 a.m.
Thank you, Your Honor.
We have to wait for the sheriff's department to swap them out.
Okay. Keep in contact with your attorney while you're at Harbor Hall, okay?
I will do, Your Honor. Thank you.
Good luck to you.
Thank you.
You're all set. You can notify the department there.
Yep, will do. Thank you again.
Mr. Melton never call in, or?
No,
Okay.
I have not seen him at all. Do you want me to have my office attempt to contact his office?
No, we'll just adjourn it. So that leaves two people, huh? That leaves.
Yeah, we have Shook is gonna be after Cowboy, and that's a Judge Evans case. And that's what Mr. Dieter is on. That was temporary scripture. Prayer Karen.
Very thankful. As soon as we're done, we're gonna need, William Swift.
All right. Mr. Conley?
Yes.
Find the cases of People versus Donald and Robert Cobley. Counsel identified for the record.
Schumer's asking on behalf of people.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Coble.
You are Donald Robert Cobley?
Yes, sir.
And in file number 21-6598-FH, set as a status conference. Pretrial summary has been forwarded to the court. Have you received a copy of that one?
I have, Your Honor.
And have you talked with Mr. Cobley about it?
I have, Your Honor. Mr. Cobley told me he wanted to think over it over the weekend, and Mr. Cobley, we talked about what was offered in the new case. You intend to accept the offer?
Yes, I do.
All right. And how old are you?
I'm 39 years old, sir.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And Mr. Rowe, you've gone over the information with your client?
I have, Your Honor.
And is he waiving the reading of the information for today's purposes?
He is, Your Honor.
And he's continuing his waiver of the preliminary examination, is that correct?
That's correct, Your Honor.
Mr. Cobley, you're charged with police officer assaulting, resisting, or obstructing. That is a felony, carries a maximum penalty of 2 years in prison and or a $2,000 fine. Minimum is discretionary with the court. You're also being charged as habitual offender, fourth offense, which means that maximum could be 15 years in prison. The minimum is still discretionary with the court. You understand the charge and the possible penalties?
Yes, sir.
There's one of three possible pleas you may make to this charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand that one of three possible pleas you may make?
Yes, sir.
Answering to count one, police officer assaulting, resisting, or obstructing, how do you plead?
Guilty.
Answering to habitual offender, fourth offense, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be?
Yes, sir.
Court further informs you that if your pleas are accepted, you will not have a trial of any kind and therefore give up the following rights: the right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. You understand these rights?
Yes, sir.
You understand by pleading guilty, you give up each and every one of those rights.
Yes, sir.
Ms. Ambrositis, what is the plea agreement?
In return for the defendant's plea of guilty as charged, the people would agree pursuant to Briggs and Killebrew that there would be a 7-month cap on any initial incarceration. This would also run concurrent with his probation violation sentence in 18-006-033 FH and any other sentence he might be currently serving.
Mr. Rowe, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Copley, did you hear it was put on the record as the plea agreement?
Yes, sir.
Did you understand it?
Yes, sir.
And are you in agreement with it?
Yes, sir.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No, sir.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, sir.
All right. Do you have any questions about what the court has told you?
No, sir.
Have you understood everything that the court has told you?
Yes, sir.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, sir.
Drawing your attention to on or about March 15th of 2021, were you in Hayes Township, Clare County, Michigan?
Yes, sir.
And did you assault, batter, wound, resist, obstruct, oppose, or endanger Bradley Feiger, the sheriff deputy with the County of Clare County Sheriff's Office?
Yes, sir.
And at the time you knew he was doing his duties as a sheriff deputy?
Yes, sir.
And did he tell you to do something and you failed to do it, or?
He reached into the car toward me and I pulled my arm away from him, sir.
All right. So he wanted you to exit the car and you refused to do so?
I told him I could get out on my own, but I did pull my arm away from him, sir.
All right. So you weren't getting out fast enough for him, is that correct?
I believe so, sir.
And is it true you were previously convicted on or about November 27th of 2018 of possession of methamphetamine in the 55th Circuit for Clare County, state of Michigan?
Yes, sir.
And were you previously convicted on January 4th of 2021 of the offense of possession of methamphetamine in the 55th Circuit Court for Gladwin County, state of Michigan?
Yes, sir.
And were you also convicted on January 4th of 2021 of the offense of attempted felony bond, absconding or forfeiting in the 5th Circuit Court for County of Gladwin, state of Michigan?
Yes, sir.
Ms. Ambrositis, are you satisfied with the factual basis, or do you wish to ask any questions?
Satisfied, Your Honor.
Satisfied with the factual basis, Mr. Rowe?
I am, Your Honor.
Does court comply with the court rules, Ms. Ambrositis?
Yes, Your Honor.
Does court comply with the court rules, Mr. Rowe?
It has, Your Honor.
Court has not agreed upon the possible plea or the possible sentence. Either the prosecutor, defendant, or anyone acting in the interest of either. Court is convinced the plea is accurate, has been freely, voluntarily, understandably, and knowingly made. Plea is accepted. Ordered on the record of this court. Bond is canceled. Sentencing will be set for June 28th at 10:20 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report.
Your Honor, if I may.
Case number 18-6033-FH. That is adjourned to the same date and time for sentencing. That was the probation violation on which he's already pled. Mr. McConnell?
Two things, Your Honor. Is it possible to get that sentence date out maybe 2 weeks further to give us time to prepare that PSI?
It's possible, but let's try and do it. If we can't, then we'll adjourn it.
Very well, Your Honor. Mr. Cobley, is your current address still 3060 Hazel Drive here in Harrison?
Yes, it is.
And do you have a current phone number?
I do not. My phone is shut off now that I am sitting in Clare County Jail.
Okay, the packet will be sent over to you with further instructions. Thank you. That's all, Your Honor.
All right, you're all set, Mr. Cobley.
All right, thank you, Your Honor.
Your Honor, I believe that concludes all my cases this morning.
I believe it does. Thank you.
Thank you, Your Honor. Have a good afternoon.
You too.
And then the last one is Mr. Shook, and as soon as he comes over, there's a couple more of those and a judgment for you. Stacy, what's his case number? 20-006518. F8, and it's William Sheldon Shook. Thanks.
Yeah, we're down into this room down here. Should be, I'll have another chair in there. Okay, thank you. All right.
Todd?
Thank you.
You do. He's just muted. Todd, are you there? There we go.
Hello.
Calling the case of the people versus William Sheldon Shook. Counsel identify for the record, please.
Members, I speak on behalf of the people.
Thank you, Your Honor. Todd Dietrich appearing on behalf of Mr. Shook.
And you are William Sheldon Shook?
Yes, I am, Your Honor.
You're here on a contempt of court charge for failure to appear at sentencing back in February. That's a misdemeanor, carries a maximum penalty of 93 days in jail and or a $500 fine. How do you wish to proceed, Mr. Diedrich?
Your Honor, I'd ask that the court enter a plea of not guilty at this time, please.
All right, not guilty, plea will be entered on behalf of Mr. Shook. Bench warrant, the bond was set at $3,000 cash in defendant's name only. Did you want to address bond on this matter?
Mr. Shook, are you able to bond out on that, or do you need me to address the bond?
No, I'm not able to find out on that at this point. No.
Your Honor, I would ask the court to consider a 10% cash surety bond.
The court will not. Not going to change what Judge Evans did on this matter. Has a PSI been done with Mr. Shook?
Yes, Your Honor.
All right, we'll put this on Judge Evans' docket for June 7th at your time of 9:40 for sentencing.
Thank you, Your Honor.
You can handle the contempt of court charge also. You're all set. We're in recess.
All right. All right. 55th Circuit Court is now in session. The Honorable Roy J. Meeks presiding.
You may be seated. On the case of Teresa Beth Saleh versus Abdullah Mohammed Saleh. You are Teresa Beth Saleh. You are Abdullah Mohammed Saleh.
Yes, Your Honor.
All right. Both of you raise your right hands and be sworn.
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Teresa. Were you a resident of the state of Michigan at least 180 days before filing this complaint?
Yes.
And a resident of Clare County at least 10 days before filing?
Yes.
And you stated in your complaint that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. Was it true then?
Yes.
And is it true today?
Yes.
Are there any minor children from this marriage?
No.
Are you currently pregnant?
No.
And you're just asking that neither party be awarded spousal support?
Correct.
You understand if you're not awarded spousal support, you're forever barred from receiving spousal support?
Yes.
And you're asking that each party be awarded whatever personal property they may have in their possession?
Yes.
And each party being responsible for any debts in their own name?
Yes.
And that each party keep whatever vehicles they may have in their own name?
Yes.
And is there any real estate owned by the parties?
No.
And you're asking that each party be awarded whatever pension or retirement benefits they may have in their own name?
Correct.
And you're asking that your name of Stevens be changed to
Yes.
your last name, so you'll be known as Teresa Beth Stevens?
Correct.
Is that for any fraudulent purpose?
No.
What?
What is that spell?
Stephen's. Is that correct?
Yes.
As part of the settlement, Abdullah is to return to you $7,973 from an IRS tax refund?
And that has happened.
That's already occurred.
Yes.
And how about the rest of that settlement?
Everything is resolved.
Everything's resolved.
Yes.
Is that correct, Mr. Salou?
Sir, I heard some of it. I didn't hear most of it. I'm sorry.
Okay. Basically, as far as the settlement goes, there was a page added to the judgment of divorce that included a settlement of you making some payments to her, and those are all occurred. Is that correct?
Yes, sir.
And you're not asking for any spousal support. Is that correct?
I beg your pardon, sir. Could you say that again?
You're not asking for any spousal support?
No, sir.
And you understand if you're not awarded spousal support at this time, you're forever barred from receiving spousal support.
Correct.
All right. And you got all the personal property that you want in your possession, is that correct?
Most of it, some of it, but most of it is in her possession, which we agreed that I will pick up.
Okay.
Clothing.
Okay, so clothing he still has to pick up, okay.
Yes.
And you're agreeable with that?
Yes.
All right. And you're agreeable that each party receives whatever pension rights they may have in their own name, is that correct?
Yes, sir.
All right. That each party is going to receive whatever vehicles they have in their own name, is that correct?
Yes, sir. I have an issue with that, sir, because we had agreed to give the vehicles some time ago, and I transferred the vehicle I had into my name, but she did not transfer the vehicle into her name, and I've been getting tickets in my name. And that's become an issue.
They're not tickets, they're tolls.
Tolls, okay.
Toll roads in Florida, where they take a picture of the license plate and send it to him.
All right. And so have you taken care of that issue?
Well, he's got to mail me the second one. I did do the first one. It's $6.
Okay.
And he hasn't mailed it to me yet. So when I get that, I will absolutely take care of that.
So is that the title you're talking about? Or?
It's just, no.
The ticket.
It's the toll, yes.
Okay.
So it's not the toll that's bothering me. What's bothering me is.
Yeah, so I guess if they're taking a picture of the license plate, have you had the license plate transferred over to you?
No, when he left in December, I said I would do it when I came back from Florida, and he was okay with that. And I since had a conversation that said, I will wait until the divorce is final. I can make my last name Stevens and put it in the proper last name at that time. He was okay with it.
So you'll do that within 30 days?
Oh, absolutely.
Okay.
Absolutely.
You hear that?
Yes, sir, I heard that. I am fine with that. I'm absolutely fine with that.
All right. Anything else from either party?
No, Your Honor.
Fine with me, sir. Fine with me, Your Honor. I want to make life easy for you too, Your Honor.
Okay. From the proofs that have been presented, there appears there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage can be preserved. A divorce shall be granted. Neither party is awarded spousal support. Each party is awarded personal property in their possession. Each party is responsible for any debts in their name. Each party is awarded whatever pension or retirement benefits they may have in their own name. Plaintiff's name of Stevens is restored. The court is signing the judgment. The judgment is not final until it's recorded in the clerk's office.
When will that be, Your Honor?
This afternoon, and if you want to stick around, you can get your copy of it.
She can get both copies for service as well.
Okay, so then you can mail him his copy.
Perfect.
Did you hear that? She'll mail you your copy, okay?
That's fine, Your Honor. Thank you so much. I appreciate that.
You're all set.
Thank you, Your Honor.
Thank you, Your Honor.
We're in recess.
All rise.
Well, as soon as I'm ready.
All rise. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
May be seated. On the case of Jennifer Lynn Tilson versus Joanna Lynn Tilson. You are Jennifer Lynn Tilson?
Yes, Your Honor.
From the record, there's been service of process upon the defendant. Fault has been entered. Certificate of mailing of the default. Notice of final divorce hearing has been filed. I don't see a proof of service of the final divorce hearing. Did you mail her a copy?
I did not, Your Honor. I was told by one of your clerks that if I did mail it. I mailed it that day, and that I didn't have to do a proof of service. If I mailed it that day, it's at the bottom of that default.
That is for the notice of default, but for the notice for today's hearing, there needs to be a proof of service also.
It was attached for the default request and entry. They were mailed together.
Okay, all right. And she's failed to appear here today. Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And you are Jennifer Lynn Tilson?
I am.
And prior to filing this complaint for divorce, were you a resident of the state of Michigan at least 180 days?
Yes, Your Honor.
And a resident of Clare County at least 10 days?
Yes, sir.
And you stated in your complaint there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage can be preserved. Was that true then?
Yes, Your Honor.
And is it true today?
Yes, Your Honor.
Are there any minor children from this marriage?
No, Your Honor.
Are you currently pregnant?
No, Your Honor.
And do you know if she's currently pregnant?
No, she is not.
All right. And you're not asking for any spousal support, is that correct?
No, sir.
And you understand if you're not awarded spousal support, you're forever barred from receiving it?
Yes, sir.
And you're not giving her any spousal support, is that correct?
That is correct.
Is there any real estate owned by the parties?
No, sir.
And you're just asking that you be awarded whatever personal property you have in your possession and she be awarded whatever personal property she has in her possession, is that correct?
That is correct, sir.
And you're asking that each party be awarded whatever retirement benefits they may have in their own name?
That's correct.
Anything else the court should know?
No, Your Honor.
I know in your petition you have it down for her to have her last name changed, but without something in writing that she wants it changed, the court's not gonna grant that.
Right.
But if she does want it changed, she can file a petition in this file, a motion to have it changed. All right?
Yes, sir.
From the proofs that have been presented, it appears there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage can be preserved. A divorce shall be granted. Neither party is awarded spousal support. Each party is awarded the personal property in their possession. Each party is awarded whatever retirement benefits they may have in their own name. Statutory insurance clauses included. Any beneficiary rights are extinguished. The court is signing the judgment. Judgment is not final until it's recorded in the clerk's office. Anything else you wish to say?
No, Your Honor.
You're all set, then you can sign off.
Thank you.
In the case of Jenna Lee Gardner versus Andrew Ivan Gardner,
I'm here.
or Andrew Ivan Gardner.
Yes, sir.
We don't have the plaintiff.
I let her know. I mean, she's the one that set all this up and she sent me the paperwork for it, so.
Okay. And she's changed her mind or just forgot about it?
She might have just forgot about it. I guarantee she didn't change her mind.
Okay. Well, we don't, did they submit a judgment of divorce either or no?
I don't have one for that.
Okay. All right. Well, she's the plaintiff in this matter, so we have to have her testimony to some respects.
Okay.
Do you have an agreement as to the property settlement and stuff?
The agreement we have is once the divorce is finalized, that she's gonna refinance the house into her name and she's gonna keep it.
Okay. And what, you get your personal property, she gets her personal property?
Yep. And then she's gonna keep the house.
All right, and there's not gonna be any spousal support?
No, sir.
All right. And any payments from her to you or you to her?
The only payments from me to her would be for our, we have a debt consolidation deal going. And we still have our phones on the same plan. So that's the only money that I'd be sending to her is about $180 a month.
Well, without her being present, the court is hesitant to go forward with this.
Okay.
So you should contact her and have her reschedule a new date, okay?
All right, sounds good.
All right, thank you.
Thank you.
In the case of Jody Lynn LaFave versus Edward Joseph LaFave, you are Jody?
Yes, Your Honor.
And you are Edward? Can you hear us, Edward?
He has no audio.
No audio. You muted or we muted or?
No, it's just he doesn't have, so when he signed in, he must not have selected to participate in audio
Okay.
because there's not even a microphone next to his name. It's trying to connect now, so there we go. We got him.
All right. You are Edward? Can you hear us?
Mr. LaFeeve, can you hear the court?
Turn it.
That's what I'm trying to send him a message.
message that says, please turn up your volume. Mr. Lafave, can you hear the courtroom?
Yes, I can now.
All right, okay. Would both of you raise your right hands and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So
help me God.
All right. And I'm gonna start questioning with Jody, because she's the complainant petitioner. And were you a resident of the state of Michigan for at least 180 days before filing this complaint?
Yes, Your Honor.
And a resident of Clare County at least 10 days?
Yes, Your Honor.
Stated in the complaint that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. Was that true then?
That is true.
And is it true today?
Yes.
Are there any minor children from the marriage?
No, Your Honor.
Are you currently pregnant?
No, Your Honor.
You're not asking for any spousal support, is that correct?
That's correct.
You understand if you're not awarded spousal support at this time, you're forever barred from receiving spousal support?
I understand.
And you're just asking that each party be awarded the personal property in their possession?
Yes, Your Honor.
Is there any real estate involved?
Yes.
All right, and was that, did both of you own real estate or just one of you?
He purchased a home when we were married,
All right.
but
And
I don't.
What's gonna happen to that place?
That's up to him. That's his. I don't want that.
All right. And is that located at 3565 Milky Way, Lewiston?
Yes, Your Honor.
All right. And you're just asking that each party be awarded whatever retirement benefits they may have in their own name?
Yes.
And you wish to have your last name changed?
Yes. Back to Sexton.
Okay, and that's for any, is that for any fraudulent purpose?
No, Your Honor.
And that's SEXTON?
Yes.
Anything else the court should know?
No.
And Mr. Lafave, you heard everything that she said and testified to?
Yes, sir.
And you're in agreement with it?
Yes, sir.
And you're not asking for any spousal support, is that correct?
That is correct.
And you understand if you're not awarded spousal support, you're forever barred from receiving spousal support?
Yes, sir.
From the proofs that have been presented, it appears there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage can be preserved. There's a message up on the screen. And a divorce shall be granted. Neither party is awarded spousal support. Each party is awarded the personal property in their possession. Each party is awarded whatever retirement or pension benefits they may have in their own name. Statutory insurance clauses included. The marital home located at 3565 Milky Way Road, Lewiston, is awarded to the defendant. He shall hold the plaintiff harmless from any debts on that property. Divorce is not final until this judgment is signed by the court and recorded in the clerk's office. And we'll send you out copies to your addresses. Anything further?
No, Your Honor.
All right, you're all set then.
Thank you very much.
Thank you.